Hi, I'm Ed Farrell, a construction law attorney here at Cummins & White. Today, I will be giving a presentation on home improvement contracts under the California Business and Professions Code. Specifically, this will be a primer for you contractors out there who need to have compliant contracts on every job that you go on. So what's a home improvement contract? Well, luckily there's a statute on point. It's an agreement written between a contractor and an owner, or between a contractor and a tenant, for any home improvement on a dwelling or residence in excess of $500. Home improvement is a broad, wide term, right? Absolutely. It includes the repair, remodel, or alteration of any residential property. It also includes the installation of home improvement goods or furnishing, everything from carpets to fencing to HVAC. Any good affixed to the property, whether severable or not, comes under the definition of a home improvement. So if you're working on a home improvement project and you know you need a contract, what needs to go in it? Luckily, there's a statute for that too. Business and Professions Code Section 7159 provides a detailed list of all information that needs to be put in the contract. At a base level, the contract needs to be written, legible, and delivered and signed by the owner prior to the work beginning. In this slide, I provided a detailed list of all the information that needs to come in the contract. Everything from the name, address, and license number of the contractor to change order work requirements. The other thing in a home improvement contract that's very important is a notice to the owner of lien rights. In this slide, I provide a good sample of what that notice looks like. It basically defines for an owner what lien rights are, what a preliminary notice is, and most importantly, how an owner can protect his property from being liened by any material supplier or contractor who has not been paid. The other important aspect of a notification in these contracts to the owner is a notice of cancellation. Now, these notices need to be provided in the written contract unless the contract was negotiated at the contractor's place of business, the contract is subject to a 7-day right to cancel, or the contract is subject to licensure under the Alarm Company Act. In most cases, a notice of cancellation will be provided. So how do you know which notice to provide? In most cases, the contract will have to give an owner a 3-day notice. Now, the specific text of that notice is provided at the statute that's quoted in this slide. The text must be at least 12-point boldface type, and it must have a space for the owner's signature. Most importantly, a duplicate copy of the notice must be provided at the back of the contract that can be easily detachable by the owner, who could then sign it and then send it. In this slide, I provide a good copy of a cancellation notice that has been provided in the past. As you will see, in bold it says this is a cancellation notice, and it's almost formatted as a letter to the contractor that the owner can easily date and sign and then send to the contractor to cancel the contract. Now, as mentioned, if your job doesn't come under a 3-day notice to the owner, what other notices may have to be provided? Well, in some situations, a 5-day notice needs to be provided. In those situations, the owner or the customer of the services is a senior citizen. As to the requirements, those requirements for a 5-day notice are almost the exact same as a 3-day. In those rare circumstances, a 7-day notice is required. Now, those are only provided for contracts for the renovation or repair of residential premises that have been damaged by sudden or catastrophic events. In certain situations, contractors get on jobs and they don't have a home improvement contract. What is the repercussions from that? Unfortunately, it can be kind of serious. A violation of the home improvement contract laws is a misdemeanor. It's also a cause for discipline by the contractor's state license board and can show up as a derogatory on a license. Also, a contractor may not be able to enforce certain remedies against an owner who breaches. A non-compliant contract may still be enforceable when equitable, but even in those cases, a contractor without a contract in place with the owner would be waiving the ability to obtain some damages from breach. The main takeaway for a contractor here is to do the work and diligence and have a compliant home improvement contract that's entered into on every job. Thank you for your time. If you have any other questions regarding home improvement contracts, please contact me, Ed Farrell, at Cummins & White. Thank you.